An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman. Shaw versus Reno, 1993. The 15th Amendment prohibits the states from denying the right to vote based on, quote, race, color, or previous condition of servitude. The 15th Amendment also grants Congress the, quote, power to enforce this right by appropriate legislation. In 1965, Congress used this power to enact the Voting Rights Act, or VRA. This law has been amended several times. Section 2 of the VRA prohibits the states from, quote, denying or abridging the right of any citizen to vote on account of race or color. Section 3 of the VRA authorizes the United States Attorney General to sue a state that violates Section 2. Section 4 of the VRA identifies certain states, counties, and cities that had a history of denying voting rights. These jurisdictions were subject to a process known as preclearance. Pursuant to Section 5 of the VRA, covered jurisdictions that are subject to preclearance cannot unilaterally make changes to, quote, any voting qualification or prerequisite to voting. Rather, a covered jurisdiction has two options. First, the jurisdiction could persuade the federal court in the District of Columbia that the new voting law, quote, does not have the purpose and will not have the effect of denying or abridging the right to vote on account of race or color. Alternatively, the jurisdiction could submit proposed changes to the United States Department of Justice for approval. Study Guide. In Shelby County versus Holder, 2013, the Supreme Court declared unconstitutional Section 4's list of covered jurisdictions. At the time, the VRA's coverage formula had not been updated in 4 decades. As of now, the jurisdictions identified in Section 4 are not subject to the preclearance process. After the 1980 census, North Carolina had 11 seats in the House of Representatives. Over the next decade, North Carolina's population increased. Following the 1990 census, North Carolina became entitled to a 12th seat in the House of Representatives. North Carolina enacted a new legislative map that included 1 congressional district with a majority of black voters. Study Guide. A district with a majority of minority voters is known as a majority-minority district. At the time, 40 of North Carolina's 100 counties were subject to preclearance under the VRA. Pursuant to Section 5 of the VRA, North Carolina submitted the map to the Department of Justice. However, Attorney General William Barr objected to the plan. He determined that the state, quote, could have created a second majority-minority district. North Carolina could have appealed that decision to federal court. Instead, the legislature then drew a new map that included 2 districts with a majority of black voters, District 1 and District 12. Both districts were strangely shaped. District 1 was, quote, somewhat hook-shaped. District 1 stretched from the northeast portion of the state to the southernmost portion of the state near the South Carolina border. District 12 was, quote, even more unusually shaped. District 12 stretched, quote, approximately 160 miles long in a snake-like fashion, so it gobbled in enough enclaves of black neighborhoods. Why was District 12 drawn so unevenly? In order to sweep in enough black voters to constitute a second majority-minority district. The United States Attorney General did not object to the revised plan. However, some voters challenged the plan. They argued that the plan was an unconstitutional racial gerrymander that violated the Equal Protection Clause of the 14th Amendment. Ruth O. Shaw and other North Carolina voters sued Janet Reno, who had succeeded William Barr as the Attorney General. The voters contended that the plan arbitrarily concentrated black voters in Districts 1 and 12. The purpose of this plan, the voters charged, was, quote, to create congressional districts along racial lines and to assure the election of 2 black representatives to Congress. The lower court upheld the revised map. On appeal, the Supreme Court reversed by a 5-4 vote. Justice O'Connor wrote the majority opinion, which had 3 primary parts. First, the court focused on how the map was drawn. During oral argument, Justice O'Connor observed that
District 12 is a highly irregular shape.
She found that the residents of District 12 share, quote, little in common with one another but the color of their skin, yet they are, quote, widely separated by geographical and political boundaries.
this plan, Justice O'Connor wrote, quote, bears an uncomfortable resemblance to political apartheid. Second, the court considered the legislature's intent. Justice O'Connor found that these, quote, district lines were obviously drawn for the purpose of separating voters by race. She reasoned that North Carolina's plan was, quote, so brazen on its face that it is unexplainable on grounds other than race. Third, the court selected the appropriate level of scrutiny. Generally, quote, legislation that expressly distinguishes among citizens because of their race is reviewed with strict scrutiny. To satisfy that standard of review, the law must, quote, be narrowly tailored to further a compelling government interest. This standard may also apply to, quote, rare statutes that are neutral on their face but are, quote, unexplainable on grounds other than race. That standard was warranted for North Carolina's plan. The court held that the, quote, district lines were obviously drawn for the purpose of separating voters by race. This plan, quote, requires careful scrutiny under the Equal Protection Clause, regardless of the motivations underlying their adoption. The Supreme Court did not decide if North Carolina's map satisfied the strict scrutiny test. Instead, the court remanded the case to the lower court for further proceedings. There were 4 separate dissenting opinions. Justice White wrote the first dissent. He observed that North Carolina intended to, quote, equalize treatment and to provide minority voters with an effective voice in the political process. Indeed, with the new districts, North Carolina elected its first black representatives since Reconstruction. Justice White concluded that the, quote, Equal Protection Clause of the Constitution surely does not stand in the way of this goal. Justice Blackman wrote the second dissent. He concluded that states can consciously use race in redistricting unless the plan, quote, denies a particular group equal access to the political process or minimizes its voting strength unduly. Justice Stevens wrote the third dissent. In his view, legislative maps cannot use race, quote, to enhance the power of the group in control of the districting process at the expense of any minority group. but legislative maps can consider race, quote, to facilitate the election of a member of a group that lacks such power. Specifically, a state can draw boundaries based on the, quote, assumption that people in a particular minority group will vote in a particular way, so long as those district lines are used to benefit that group. Study guide. Should it matter to the court that Shaw and the other voters were white? The majority vigorously disagreed with Justice Stevens' approval of racial gerrymanders that favor the minority. Justice O'Connor countered, quote, that equal protection analysis is not dependent on the race of those burdened or benefited by a particular classification. Indeed, she wrote, the court reviews racial classifications with strict scrutiny, regardless of whether they, quote, burden or benefit the races equally. Justice Souter wrote the fourth dissent. He explained that in any racially diverse population, legislative maps will, quote, nearly always require some consideration of race for legitimate reasons. Souter added that so long as people of the same race tend to vote as a bloc, quote, legislators will have to take race into account in order to avoid dilution of minority voting strength. However, Shaw contended that, quote, deliberate segregation of voters into separate districts on the basis of race violated their constitutional right to participate in a colorblind electoral process. Here the voters invoked Justice John Marshall Harlan's dissent from Plessy v. Ferguson, 1896. That landmark opinion stated that, quote, our Constitution is colorblind and neither knows nor tolerates classes among citizens. On this narrow point, the majority agreed with the dissenters. The court rejected Harlan's colorblind principle with respect to apportionment. Justice O'Connor concluded that, quote, race-conscious redistricting is not always unconstitutional. But the majority disagreed with Justice Souter's broader point. Justice O'Connor wrote that legislative maps can consider race to some degree. However, North Carolina's map that benefits racial minorities still, quote, threatens to undermine our system of representative democracy. This racial gerrymander, quote, signals to elected officials that they represent a particular racial group rather than their constituency as a whole. According to the majority, so-called benign racial classifications are still reviewed with strict scrutiny. Study guide. According to the majority, how should states consider race when drawing legislative maps? The court concluded that, quote, racial gerrymandering, even for remedial purposes, may balkanize us into competing racial factions. And racial gerrymandering, quote, threatens to carry us further from the goal of a political system in which race no longer matters. America should, quote, continue to aspire to this goal, the court stated, which is embodied in the 14th and 15th Amendments.